Hi folks, welcome to SQE1 window, and in our chapter 5 of criminal law we talk about property offences that mainly rests on two different laws: Criminal Damage Act 1971 and Theft Act 1968. I hope I'm right. So property offences rest on two pillars: criminal damage on one side, dishonesty offences on other side. For SQE1, the exam hotspots are distinguishing between theft, robbery and burglary. These get tested constantly and we mix them up all the time. So here is our golden rule: always analyze elements in order, don't jump around, work through each element systematically, actus reus first and then mens rea. We are dealing with two key statutes: the Criminal Damage Act 1971 and Theft Act 1968. Both are still Victorian era or post-war legislation that's been heavily interpreted by court, so case law matters enormously. So criminal damage protects tangible property from damage or destruction. There are three main offenses you need to know: basic criminal damage, aggravated criminal damage, and arson. So the key thing to remember is the lawful excuse can completely defeat liability, even if you're damaged, like you have damaged someone's property intentionally. If you have lawful excuse, you are not guilty. The statute is the Criminal Damage Act 1971, with the main provisions in section 1, 5 and 10. Master these sections and you are halfway there. So to start with basic criminal damage, please excuse me for the font color. So basic criminal damage under section 1 subsection 1 has four elements you must prove. First, damage or destroy. Second, property belonging to another. Third, without lawful excuse. And fourth is mens rea, intention or subjective recklessness. That mens rea point is crucial since RVG in 2003, recklessness is subjective. The defendant must foresee the risk of damage. This overtuned the old objective test. So your checklist: did they damage or destroy the property? Did it belong to someone else? Did they lack lawful excuse? Did they intend it or foresee the risk? So get this structure in your mind once you are talking about criminal damage. So what counts as damage? That's also very interesting and important. So what actually counts as damage? The test is whether the property's value or usefulness has been reduced. Here is the interesting bit. Damage can be temporary impairment. It does not have to be permanent. In Rose's case, that involved mud on police cell wall. That was damage because it required cleaning to put it back into its character. So but not every mark counts. There is line between trivial interferences and actual damage. Case like Hardman, illustrate this. Think about graffiti. That's clearly damage because it reduces value and requires removal. Think about like trampling flowers in a garden. That's damage. But tiny scratches that don't affect usefulness, probably that's not a damage. The question is always, has the value or usefulness been impaired? That's your guiding principle once you are talking about damage. So property and belonging. Property for criminal damage means tangible property, things you can touch. This includes money. Intangibles like intellectual property are excluded, though if you damage the physical medium they are recorded on, that counts, like for example books and all. So, or a painting. Belonging to other is broader than ownership. It includes anyone with control, like interest or charge over the property. Section 10 defines this. R.V. Smith is the key case. He damaged his own flat's fixture, but they belonged to his landlord once installed. This shows belonging to another, so that's very important and that's very broad. Watch out for scenario where someone damages his own property, but someone else has an interest in it at that point. So aggravated criminal damage under section 1 subsection 2 is more serious. Here is the key difference. The property can be your own or someone else. Ownership does not matter for this offense. What matters is that you damage property and endanger life by doing so. Both elements must be present in aggravated one. The mens rea covers both the damage and the endangerment. You must intend or be reckless as to both damaging and endangering life. This is much more serious offense with much higher penalties because of the life endangerment element. It recognizes the property damage becomes far more serious when someone puts life in danger. So we got steer principle here. This is high yield for SQE1, so pay close attention. The steer principle says the danger to life must come from the damage itself, not merely from the act that causes the damage. So RV steer is the classic case. Shooting at someone through a window. So the danger came from the bullet, not from the damaged window. So it's basic criminal damage plus attempted murder, not aggravated criminal damage. So in this case, so compare this one pushing a stone off a bridge onto traffic. Here the danger came from the falling stone damaging vehicles. So it is aggravated at that point because it is putting life in danger directly at that point. So Webster and Dewey apply the same principle. Always asks, does danger come from the damaged property itself or from something else? This trips up tons of students, so really understand this distinction between. So arson and lawful excuse. Arson is simply criminal damage by fires under section 1 subsection 3. It can be basic or aggravated, but the damage must be caused by fire in arson. So now lawful excuse under section 5 gives you two defenses. First, honest belief that the owner would consent. Second, damaging property to protect other property where you believe that means are reasonable at that point. Crucially, these beliefs are subjective. What matters is whether you genuinely held the belief, not whether it was reasonable, at that point. So Dickinson's case, established this. She was drunk and broke into what she thought was her friend's house. Her drunken belief in consent was still a lawful excuse. So, however, intoxication-induced belief don't work for the second defense about protecting property. The statute draws this distinction explicitly. So now let's switch to dishonesty or theft offenses. So theft under section 1 of the Theft Act 1968 has 5 elements and you must need all 5. 1. Appropriation, assuming an owner's right. 2. Property, something that can be stolen. 3. Belonging to other, someone else has an interest. 4. Intention to permanently deprive, not just borrow. 5. Dishonesty, acting in a way society considers dishonest. Missing any one element mean no theft. This is critical. Don't just assume someone dishonest and stop there. Work through all 5 elements systematically. This 5 element structure is your framework for every theft question and we need to master it. So the next thing is appropriation. What does it mean? Appropriation is assuming any right of an owner. Morris said it does not have to be all the right, just any right. So even price switching in a supermarket is appropriation. Here is what's controversial. Consent does not block appropriation. So even if the owner consents or even makes a gift, there can still be appropriation. This seems odd, but it is the law. For example, you are given permission for something, but you went beyond that. At that point, it is different. Belonging to other includes possession and control, not just ownership. He stole his own, in Turner's case, he stole his own car from the garage repairing it because the garage had possession at that point. Once again, it is belonging to other. For example, you left your car to garage and they are fixing it. So in order to avoid payment, you just stole your own property from there. That's also belonging to other at that point in their possession. So now Section 5, subsection 3 and 5, subsection 4 extend belonging even further. Section 5, subsection 3 covers property received under an obligation like Hall and Davidge, like, cases involving deposits and household expenses. So section 5 and subsection 4 covers property gotten by mistake, where there is a legal obligation to return at that point. Once again, it is belonging to other. So all of it, these extension catch situation where you might think it's mine now, but legally it still belongs to other. So keep in mind the garage example where you left your car to repair in garage. At that point, that belongs to garage. You cannot just go at night, sneak into and take your car back without their permission. So intention to permanently deprive, ITPD. So is the fourth element. Borrowing is not normally theft unless you are treating the thing as your own to dispose of regardless of the owner's right. So section 6 covers this. Borrowing is only theft if it is equivalent to outright taking. Lloyd says, in that case, it says that this means borrowing until the goodness or virtue is gone. Think of ticket to a one-off event. If you borrow them for the event, that's likely permanently depriving the owner. Like, you use ticket on concert or cinema, it's gone. So now dishonesty, this has evolved. Modern test for this has confirmed that there are two stages. First, establish the defendant's actual state of knowledge or belief as to the fact. Second, was their conduct dishonest by the standards of ordinary decent person, like what it is objective test. So section 2 gives 3 specific situations that negate dishonesty: believing you have a legal right, believing you would have the owner's consent, or believing the owner can't be found by reasonable step. If the defendant dishonestly holds any of these beliefs, that's not dishonest, like, not dishonestly. If the defendant honestly holds these beliefs, at that point it does not pass the test of dishonesty. So there are different offenses here, so we will talk about it: robbery, burglary, and we'll try to look at, like, how you can just judge them in your SQE exam. So robbery under section 8 is theft plus force or threat of force immediately before or at the time of stealing. So that's what is tested in SQE1. So in order to steal, there is a force immediately before or at the time of stealing. You need completed theft plus force. No theft means no robbery. So the force can be minimal. So in Dawson case, like, shows a nudge is enough, even, like, So another case shows snatching a bag count, like, with force at that point. Hale says, like Lady Hale says, at the time of stealing continues with the theft is ongoing, even after grabbing the property, if you are still on the premise at that point. So like at the time or before, or immediately before or at the time of that one. So burglary under section 9, that's different, has 2 forms. Section 9 subsection 1a is entering a building or part of building as a trespasser with intent to steal, inflict GBH, or do unlawful damage. It's the intent on the entry that matters in this case. In section 9b is entering as a trespasser, then stealing or attempting to steal, or inflicting or attempting to inflict GBH. Here the offense happens after entry, and there is at the time of entry. So you need to understand different cases. Call in on entry, you must be trespassing. So consent defeat burglary. So another case is a shop, like if you enter a shop, is a building, but you can still trespass in parts of it. Like, for example, there is some storage space that you are not allowed to enter at that point. So So the thing is that you are at a part where you are not allowed to enter. So common pitfalls we all make is using the wrong burglary section, that is 9A, I would say, requires intent on entry, and 9(1)B requires the act after entry. That you were not intending, but once you entered, afterward you performed it, So forgetting that robbery requires completed theft. Just force without theft is not robbery. And misapplying dishonesty. Remember to check section 2 belief first, at that point. For SQE1 success, always identify which offense you are dealing with first. State all elements clearly. Apply them systematically to the fact. Don't skip elements all of damage, aggravated damage, arson, and all of it is totally different. Theft is different from robbery, and robbery is different from burglary, and in burglary it is 9A and 9B. Those are two different things. Watch for ownership trick. Property can belong to other even if the defendant owns it. A car that is left in garage. Look for lawful excuse in criminal damage. Even intentional damage might be excused. And pay attention to timing in robbery and burglary. When did the act occur relative to the entry or stealing? So that's chapter 5. I hope it makes sense. If you like it, please subscribe and share it with your friends. I wish you all the best. Ta-da!